the banks that are located in jurisdictions with comparable legal and political systems would be a good way to maintain confidence in the integrity of the information exchange. However, it may be difficult in practice to define comparability depending on the jurisdiction. Case study: U.S. EU Safe Harbor Privacy Principle. You should probably have read more of these case studies. I'm sure just blowing right through them. Let me, however, write down the EU Data Protection Directive. Here's a relatively, okay? Establishment. Safe Harbor privacy principles were created to facilitate the exchange of personal data between the U.S. and EU in accordance with both jurisdictions' data protection and privacy requirements. In 2000, the U.S. Department of Commerce issued the Safe Harbor privacy principles and a number of related documents. The European Commission subsequently confirmed that these safeguards provide adequate protection under the Article 25.1 of the EU's Data Protection Directive regarding the transfer of personal data to countries outside the EU. As part of the framework, the U.S. Department of Commerce maintains a publicly available, regularly updated list of U.S.-based organizations that have declared their adherence to the Safe Harbor policy principles. A similar arrangement was made between the governments of the U.S. and Switzerland in 2009. I'm moving onward to page 26 in the Egmont STR sharing whitepaper. Just closed out a section that was still talking about benefits. Key considerations for cross-border STR sharing and more of the benefits of STR sharing. On page 26, common or similar laws would be most important in the areas of data protection, confidentiality, and disclosure of information, as well as STR reporting. Equivalency between AML CFT requirements would ensure the exchange of confidential information, such as the content of an STR, will only be done in order to exercise the due diligence obligation. Equivalency in personal data protection and privacy protection requirements is important in order to avoid non-controlled disclosure, which would have a detrimental effect on the suspicious transaction reporting regime in general. The whole system would be challenged, and particularly enterprise-wide STR sharing, as it would infringe on the necessary trust that serves as the basis of AML. Two different methods could be used to ensure equivalency in the framework of data protection with respect to privacy and AML CFT legislation. An authority of a jurisdiction would be designated to access the equivalency of its laws with those in other jurisdictions, as is done in the EU. Another solution might be to enter into bilateral or multilateral agreements. Cross-border legal arrangements applicable to sharing of STRs that aim to ensure that the information is only used for the purpose for which it is intended, i.e. the enterprise-wide management of AML, CFT compliance, transaction monitoring, and STR reporting, and ultimately the detection of money laundering and terrorism financing, as well as associated predicate crimes. The authorities of the jurisdiction of the bank that share the STR continue to control the information and should give their consent to enable foreign authorities to use it. There is a highest level of protection of the identity of the individual that reported the original suspicion, and there are similar rules in STR reporting requirements, triggers for obligation to report timeframes, including an obligation on a head office, subsidiary, branch, or affiliate that receives a shared STR to consider whether, subject to its domestic AML CFT laws, it needs to file a related STR with the respective FIA. Making cross-border STR sharing effective. Global financial groups play an increasingly important role in combating ML and CF, especially through their reporting of suspicious transactions to FIU and indirectly to law enforcement agencies. According to the Basel Committee on Banking Supervision's consolidated KYC risk management, in order to effectively capture inconsistent patterns of suspicious transactions, there should be consistent identification and monitoring of customer accounts globally, as well as oversight at the group level. So just so you know, consolidated KYC risk management which is in the/provide. I'm going to read that. To be effective, the monitoring of customer accounts and transaction through centralized databases requires wide-ranging and robust information sharing across the financial group, including sharing of STRs and STR-related information. Policies and procedures that encourage and facilitate the proactive sharing of suspected as well as confirmed illicit activity increase the effectiveness of risk identification and mitigation, and should provide authorities with a more complete picture of attempted and actual criminal activity. However, any measures that facilitate the increased sharing of STRs need to be undertaken with due recognition of the potential risks associated with any sharing of sensitive information. Appropriate operational controls to minimize the potential for abuse or misuse need to be in place to prevent potential damage to the integrity of the STR reporting regime, which is predicated on the confidentiality and protection of information. Good relationship between competent authorities. Good relationships between international authorities will provide an additional layer of assurance that the integrity of the system can be protected. Existing legal frameworks and controls can be completed and strengthened by regular contact and information exchange between relevant authorities. This creates an environment of mutual trust and increases confidence that any sharing of STRs within financial groups is not abused by foreign governments. Operational controls within banks. Examples of operational controls may include, but are not limited to, enterprise-wide policies on the exchange of STRs and STR-related information and maintenance of retention of sensitive customer information. Well-defined procedures for the transmission of sensitive data prove it would be very difficult to establish a common security standard where there are differences between locations and IT systems and procedures. The requisite technological setup, including state-of-the-art data encryption facilities, for example, appropriate corporate governance arrangements, including oversight and control of management, and regular review of the effectiveness of current arrangements, addressing questions such as, has the increased sharing of information had the desired effect or met its objective? For example, is the enterprise-wide transaction monitoring system being regularly updated or adjusted with the latest information? Are the relevant policies and procedures being adhered to and working in practice? If breaches of protocols have been taken in the review period, how have they been remedied? How many STRs resulting from enterprise-wide information sharing have been submitted to FIUs or other government agencies? 28. An STR sharing would be particularly valuable. Customers in multiple jurisdictions. According to feedback received from some banking industry associations, situations where customers conduct business within the same financial group in different jurisdictions are ideally suited to the concept of enterprise-wide sharing of STRs. Such transactions generally occur in the normal course of their business with the bank, but may come to the attention of staff if they do not accord with their knowledge of the customer. The sharing of STRs within financial groups could prompt the probing of the customer's activity in another jurisdiction, which might result in the identification of other suspicious activity, and provide valuable additional information which would be able to be provided to domestic authorities. Terrorist financing. Terrorist financing is difficult to detect and can involve legal sources of funds. Transaction monitoring is likely to play a key role, particularly where customers that are assessed as higher risk due to transaction history and or country of origin, for example, are involved. An initial suspicion by a bank that a transaction may involve the financing of terrorism may be confirmed if further transactions with other banks within the financial group involving the same customer or recipient of funds are reported. Such a chain of transactions would likely only be picked up if the initial suspicion was shared across the financial group and the customer or receipt is flagged for further attention. In situations where terrorist financing is suspected, it is essential that the reporting and sharing of relevant information occur without delay. The instant sharing of suspicious information within the financial group and, if confirmed by the financial subsidiary, branch, or affiliate, subsequent reporting to a foreign FIU could be a critical factor in the prevention of a major terrorist incident. International crimes. As globalization has expanded international trade and the range of organized criminal activities has broadened and diversified, the traditional hierarchical forms of organized crime groups have diminished and have been replaced with the loose networks who work together in order to exploit new market opportunities. For example, organized crime groups involved in drug trafficking are also commonly engaged in smuggling of other illegal goods. An increasing The increasing links between various categories of transnational organized crime for a more integrated approach to address this nexus, including the receipt of information from and information exchange within a global financial group to unravel complex international financial transactions, convergence of fraud and money laundering. Reports from the financial sector indicate increasing convergence of money laundering and large-scale fraud. As the use of banks to perpetrate massive fraud is becoming more prevalent, many banks are looking for combining their AML and fraud units. To effectively counter complex multi-jurisdictional fraud, FIUs and law enforcement agencies will need to increasingly cultivate partnerships with banks for proactive initiatives and to enhance our understanding of sophisticated financial transactions. Banks' ability to share STRs within their financial groups may contribute greatly to their analytical efforts to detect fraud and protect banks and innocent customers. Corruption. Proceeds from corruption are particularly likely to be transferred to a foreign jurisdiction as corrupt officials both seek to conceal evidence of their crimes and facilitate escape should they be discovered. The ability to share STRs within a financial group would increase the chances of identifying such crimes. At the same time, operational controls would be of critical importance for trying corruption-related STRs in order to ensure the STR subjects were not made aware of the STRs as a result of activities of insiders within the financial group involved in sharing of corruption-related STRs. Possible approaches to facilitate enterprise-wide STR. In order for enterprise-wide STR sharing to become reality, approaches must be considered that both preserve the benefits and reduce the risks associated with sharing. This section presents potential approaches and the advantages, disadvantages, and governmental implications for each approach. In general, each of the approaches incorporates some limitation on sharing designated to reduce the potential for violation of STR confidentiality. These limitations may also reduce some of the benefits anticipated from sharing described previously in the paper. The approaches are intended to serve as a starting point for jurisdictions to consider when implementing their own enterprise-wide STR sharing regime. The approaches presented below are not necessarily mutually exclusive. Jurisdictions may wish to consider a staged approach to STR sharing, beginning with the initial limited approach before moving on to a more wide-ranging approach. Category of offenses approach. Under the category of offenses approach, enterprise-wide STR sharing should be permitted for suspicious transactions involving classes of criminal offenses. For example, this approach may include sharing STRs for transactions that involve or appear to involve severe offenses such as terrorist financing, nuclear arms proliferation, or sale, distribution, or creation of weapons of mass destruction. When a bank files an STR that involves such an offense, the bank will be permitted to share the STR with its financial advantages. The category of offenses approach allows FAs to maintain a high degree of control over what types of STRs could leave the jurisdiction. By limiting sharing to STRs that implicate certain severe offenses, many of the perceived risks of enterprise-wide STR sharing could be mitigated, since only a small number of STRs would leave the jurisdiction. Moreover, this approach would allow a financial group to implement enterprise-wide compliance procedures for those offenses that would be most detrimental to legal and financial. Disadvantages. Relative to the other approaches presented in this section, this approach does not guarantee the same degree of confidentiality and protection of STRs. I'll just call them STRs for now. The other approach in this section incorporates limitations of the distribution of STRs, such as the jurisdiction of bank. Additionally, financial groups may view this approach as limiting their ability to implement enterprise-wide compliance programs because their STR sharing capabilities would be confined to certain offenses rather than all reportable offenses. Therefore, financial groups may not be able to realize the full potential of enterprise-wide compliance. Also, from the legal regulatory perspective, banks do not have difficulties determining which STR offenses permit cross-border sharing and which offenses do not permit sharing, depending on the level and quality of guidance provided by the FAA's regulator. Furthermore, banks are often not in a position to judge accurately the nature of the underlying criminal activity of a suspicious transaction. While they may have a suspicion about the transaction, it is left to the FAA or other competent authority to analyze the STR in combination with other information sources to evaluate relevance for possible criminal investigation. Whether this problem would result in underutilization or overutilization of the STR sharing would be case specific. In some cases,